Yes, you may. Good morning.
May it please the court. My name is Elisa Coombs, and I represent the appellant, the plaintiff in the case below, Mr. Robert Dickerson. I would like to reserve 3 minutes for rebuttal.
3 minutes?
Yes, please.
And you might speak up just
Sure.
a little. I'm a little hard of hearing.
Absolutely. This case originated in Shelby County Circuit Court. Mr. Dickerson was a patient at Lakeside, which is a psychiatric hospital in Memphis. He was inpatient there from October 29th, 2020, almost a month till November 25th, 2020. The entire time Mr. Dickerson was a patient at Lakeside, he was considered a fall risk. He actually was classified as a fall risk within hours of his admission at Lakeside, and again, the entire time he was a patient. This was both because of his scoring on the Edmondson Psychiatric Falls Risk Assessment, and independently because of his severe vision limitations. Mr. Dickerson has...
Let me ask you a
Yes.
question. The undisputed facts say that the plaintiff was placed on full precautions during his admission. What does that mean?
It is the fall risk assessment, so that additional precautions had to be taken. He was given checks every 15 minutes throughout the records.
It's a defined term then. Is that accurate?
I believe fall risk is considered a defined term.
No, the full precautions. That is a defined term.
Defined in the statute? And what, I'm sorry.
Well,
According to Lakeside,
it's a finding that the court made, or that the parties stipulated to, that the plaintiff was placed on full precautions. I'm just trying to figure out what that means. And
it's
where it
my
comes
understanding,
from.
and I don't believe it was disputed, that because of his testing
I
on this,
understand it's
he
not
was on
disputed.
fall
I
risk.
don't know what it means.
Okay, it means that the hospital was concerned that he would fall, and so additional precautions were taken, including 15-minute checks. Again, whenever, I believe he had a separate wristband so that any hospital personnel would know to help him to make sure he did not fall. Okay. He has, so independently the fall risk assessment, and then also because of his severe vision limitations. He is essentially blind. He is considered legally blind because of his severe stage glaucoma. Again, this is consistently noted throughout his records at Lakeside. Prior to discharge, Lakeside arranged Mr. Dickerson's medical transportation home. However, Lakeside did not tell the transportation company or the broker that he had been on these fall risk precautions or that he was blind or had any vision impairment. Mr. Dickerson is transported home by a third-party independent company. He stepped out of the van at the curb of his house, fell, and sustained serious injury. Prior to filing suit, the plaintiff retained Mr. Joseph Rubino, who is an expert in passenger ground transportation, regarding the standard of care that Lakeside had in arranging this medical transportation and their breach of that standard of care. At the trial court, the court granted summary judgment to Lakeside on 2 bases. One, the court found that Mr. Rubino did not meet the statutory requirements of the HCLA because he was not licensed in Tennessee or a contiguous state. And secondly, the court held that the common knowledge exception did not apply. So before you today are 3 issues. 1, whether Mr. Rubino met the statutory requirements of the Healthcare Liability Act. 2, whether the common knowledge exception applies. And then 3, whether the trial court erred on one or both of these 2 issues. To analyze the first inquiry, whether an expert meets the statutory requirements of the HCLA, a 2-step inquiry is required. This is based on the statute, the Healthcare Liability Statute itself, and the Tennessee Supreme Court opinion that I will discuss in a minute. The 2-step inquiry is 1, what is the profession of the applicable area of expertise? And 2, is that profession one that requires licensure in Tennessee? The language of the applicable section of the Healthcare Liability Act is 2926-115B, which begins, and it's the first few phrases that are important here. It begins, "No person in a healthcare profession requiring licensure under the laws of this state shall be competent to testify," and it goes on, "unless the person was licensed to practice in the state or a contiguous bordering state." The way the statute is drafted, the plain language of the statute only requires an expert in a healthcare liability action to be licensed in Tennessee or a contiguous state if that expert is in a healthcare profession requiring licensure under the laws of this state. The Tennessee Supreme Court looked at this language in Young v. Frist Cardiology. This is a case from 2020. Young involved alleged negligence during a heart procedure, cardiac surgery. The plaintiff's expert in that case was a cardiologist who was not licensed in Tennessee or a contiguous state because he had a licensing exemption during his fellowship at Vanderbilt. So he did not have a license. Much like the present case, the issue was whether that proposed expert met the statutory requirements that I just quoted from 2926-115B. The court's analysis shows this two-step inquiry that I'll talk about. First, they look to what the profession of the proposed area of expertise is, and second, is that profession one that requires licensure? The court found in the Young case that that particular profession that was the applicable area of expertise was the practice of medicine. In particular, it was cardiology. This was negligence during a heart procedure. And because the practice of medicine is a profession that requires licensure in Tennessee, then therefore, the expert, to meet the statutory requirement, would also be required to be licensed in Tennessee or a contiguous state. It made no difference that this particular expert had a licensing exemption because he was in a profession that required licensure. Therefore, he had to be licensed to meet the statutory requirement. In the present case, looking at this two-step analysis, one, what is the profession of the applicable area of expertise here? It is the arrangement of medical transportation. It is not the practice of medicine. It is not therapy. It is solely the arrangement of medical transportation. Is that profession one that requires licensure in Tennessee? It is not. In fact, there is no license that you can obtain for the arrangement of medical transportation. Therefore,
But isn't the question of whether your client was a fall risk, would not that require a medical opinion or a medical diagnosis?
it would, and that absolutely was done, but that is not our allegation of negligence. That had already been done.
But for this transportation company to be advised that your client was a medical risk, wouldn't some expert have to testify that your client was a medical risk? Was a fall risk?
Well, that is not the alleged negligence, though. It's simply the matters in the complaint. In fact, there is
But the negligence
proof
is that the hospital did not notify the transportation company that your client was a fall risk.
Right, those are known facts that were in the record. It was simply, the negligence is the failure to communicate that known information, not the assessment of whether Mr. Dickerson is a fall risk. If that were our position, I absolutely agree with you. We would need a medical professional to analyze whether Mr. Dickerson was in fact a fall risk, but that is really undisputed at this point. I mean, it's throughout his records. There's no, question about his vision limitations from Lakeside's, again, own records.
But isn't the real question, what's the standard of care, and is that standard of care, has it been violated?
Exactly, and the standard of care is whether they should have told the
Depends on which perspective you're looking at.
Well, based on the allegations by the plaintiff again, there may have been many other acts of negligence that Lakeside
If
committed,
I-
but the act of negligence that the plaintiff seeks to recover on is that single act of failing to communicate known fall risk status, known vision limitations.
But what you're saying, if I understand it correctly, is that there was a violation of the standard of care by the therapist or the doctor in not notifying the transportation company of the fall risk, either because he was a fall risk or because of his glaucoma. Is that correct?
Well, wouldn't be the doctor or the therapist. It was simply the paperwork that was filled out and passed along, the discharge paperwork that simply says.
But it's the responsibility of someone, correct?
Correct.
So you.
And that is not a
We're looking
licensed.
at the doctor and the therapist. Is that not who we're looking at?
We're looking at the discharge personnel. It happened in this case to be the therapist that had followed Mr. Dickerson throughout his month-long stay, but
And is
it has
the
nothing to do with
therapist-
the therapy that was
Is the
provided.
therapist licensed?
Not in medical discharge, and I'm not positive he was even a licensed therapist.
Well, does the therapist hold some type of license that includes him in the Healthcare Liability Act?
The Healthcare Liability Act is in play because Mr. Dickerson was a patient at Lakeside, and healthcare provisions.
I've got that.
Right, so.
I'm slow, but I got that part.
So as far as the, the licensing, there is no license for arrangement of medical transportation. It's a
That's not my
profession, all of
question.
it.
Is the therapist licensed?
I don't believe, I'll have to double check. I can come back to you on rebuttal. Definitely not in arranging medical transportation, and I
that's
believe
not my
Mr.
question.
Kohlmacher was not even a licensed therapist.
I didn't see that anywhere in here. It's my belief, or based on what I've read thus far, that the therapist was licensed. So if you don't know if the therapist is licensed, I don't know. My next question was going to be, what basically is the job responsibility of this therapist?
He had many job responsibilities to provide therapy throughout the course. We have no problem with that. We have no allegations of negligence. However, the specific act of failing to simply communicate that information has nothing to do with the therapy or the psychiatric counseling that Mr. Dickerson was receiving at Lakeside. This is a separate, paperwork type situation. All they had to do was, they're sending a blind man off in a van. All they have to do is let the driver know he's a fall risk, he needs to be assisted, and this never would have happened. I will look for the licensing for my rebuttal.
Thank you, Ms.
Thank you.
Coombs. We'll now hear from the appellee.
May it please the court, I'm Ashley Cleek. I'm with the Rainey Kaiser Law Firm here in Jackson, and it's my pleasure to represent the appellee, UHS of Lakeside, in this appeal. Unless the court prefers otherwise, my plan for the argument this morning is to first address the expert qualification issue and explain why Judge Wagner did not abuse her discretion in excluding Mr. Rubino for failing to meet the statutory requirements. And then I would like to move on and address the applicability of the common knowledge exception to the facts of this case. But first, I want to be sure the record is clear, because plaintiff's complaint contained two different claims that were alleged against Lakeside. There was the direct negligence claim, which is at issue on this appeal, but there was also a vicarious liability claim that plaintiff sought to hold Lakeside vicariously liable for its former co-defendant, United Medical Transportation. And plaintiff did not oppose Lakeside's motion for summary judgment in the trial court as it pertained to the vicarious liability claim, and so the court dismissed that by consent. So I want to be sure the record is clear that the trial court's order as to the vicarious liability claim should be affirmed irrespective of the direct negligence claim that's at issue. With regard to Mr. Rubino's qualification, I would point out that what we filed was what some of my colleagues refer to as a plain vanilla summary judgment motion. And what I mean by that is, back in the old days when this was still called medical malpractice and there was no certificate of good faith requirement, we would routinely file motions for summary judgment early on in the case, supported by the physician's affidavit saying, I know the standard of care, I met the standard of care, I didn't cause or contribute to any injury that otherwise would not have occurred. And that would force the plaintiff then to come forward with any countervailing expert testimony so we could find out, do they have an expert? Who is it? Is the expert qualified? And so in this case, we not only filed the testimony of Mr. Kohlbacher, who says, I know the standard of care, I met the standard of care, but we also...
Is Mr. Kohlbacher licensed?
No, Your Honor, he's not.
Okay.
Most of the therapists at facilities like this are either licensed clinical social worker, licensed master social worker. He was not, which is why we also filed the sworn testimony of our physician expert, Dr. Mark Hammond, because as a therapist under Tennessee law, Mr. Kohlbacher cannot render an opinion on causation because he's not capable of rendering a medical diagnosis. And so when we've submitted Dr. Hammond's testimony on causation, negating that essential element of the plaintiff's claim, that remained unrefuted in the trial court. And in plaintiff's reply brief, they made a significant concession on pages 8 and 9 that Mr. Rubino is not a causation expert. He did not offer any causation testimony. And so on the record before this court, that essential element of plaintiff's claim, there is no genuine issue of material fact. So this court can affirm the trial court's ruling on that basis alone and not even get into Mr. Rubino's qualifications. But if we go a step further and look at that, you know, I would submit that the Tennessee Supreme Court's decision in the Young case is dispositive. They've already addressed this specific argument and rejected it. You know, the plaintiff contends that Young supports their argument. I contend that it supports Lakeside's argument. But according to the Tennessee Supreme Court in the Young case, the plaintiff's position was that the requirements of Section 115B only apply if the expert is required to have a license. That's the same argument that you're hearing in this case. And so I don't think that the Supreme Court's analysis would be any different under the facts of this case when the plaintiff seeks to introduce an expert that was not licensed or practicing in Tennessee or a contiguous state during the year preceding the alleged negligence. And it makes sense because if you look at what Pandora's box would be opened by allowing this interpretation of the statute, letting professional experts come in from anywhere in the country or anywhere in the world to testify against medical providers in healthcare liability cases in Tennessee, it's completely contrary to the legislative intent, and as the Young court said, it would render the licensed and practicing requirements void, superfluous, insignificant. We can't interpret the statute that way. And so an analogous situation would be, let's say you've got a patient who sustains an injury during a surgical procedure, and that patient wants to sue the OR nurse, and they can't find a nurse to support their case in Tennessee or a contiguous state. So what do? They go to LA or New York, and they bring in a professional expert witness to testify against the nurse. Now, he or she is not an RN, they're not an LPN, they're not licensed in anything, but they're a professional sponge counter. And they can testify that nurse so-and-so deviated from the standard of care in how she conducted her pre-op or post-op sponge count. Or in a different case, bring in somebody to testify against a nurse, not licensed, they're a professional IV bag replacer. You know, the argument seeks to conflate the profession with one of the various duties of that profession. You know, in this case, arranging the medical transportation at discharge was one of a host of duties that Mr. Kohlbacher, as the patient's therapist, was tasked with carrying out during Mr. Dickerson's admission at Lakeside. And so, with regard to whether the common knowledge exception applies, that would excuse the expert testimony requirement, I can't even think about that particular issue without visualizing the proverbial fly floating in the bowl of buttermilk. Every common knowledge exception case going back to, I think, 1978, when that decision was rendered, mentions the negligence has to be as plain as a fly floating in a bowl of buttermilk for the expert testimony requirement to be excused. And fortunately, the courts
Does this not almost meet that exception? I mean, passing on that pretty basic information that had already been determined and was part of the record, medical record?
I really don't think it does, Judge Golden, and the reason is, if you look at the medical malpractice body of case law and the various categories of common knowledge exception cases that exist, when a medical provider is tasked with conveying information to a subsequent medical provider to maintain the continuity of care, that has always been a matter that requires expert testimony. The common knowledge exception cases can be packaged into three very distinct categories in which it has been found to apply. You've got intentional torts, where medical providers assault or sexually assault a patient. You've got defective products, either a wobbly x-ray stool or a broken shower chair. And then a smaller category of cases is failing to secure or restrain a patient. So the courts, in discussing common knowledge exception cases, have maintained the standard. What do we look at? Does the act require the exercise of professional judgment or medical decision-making? And those terms and that test has been repeated time and time again in every common knowledge exception case that has come out in recent years. And I would submit to the court that in the context of this case, Mr. Kohlbacher's actions clearly meet that test and would require expert testimony, because in his deposition, this was not testimony that we offered in support of our motion for summary judgment. This was testimony that Mr. Kohlbacher gave in response to questions that were asked by plaintiff's counsel in his deposition. And we've quoted this at length in our brief, all of his testimony. But the question was, okay, you're getting ready to discharge a patient. You're going to arrange a particular type of medical transportation for that patient. What goes into that decision? And he says, okay, first I go back and I look at my psychosocial assessment that I did when the patient was first admitted. It's a 8-10-page lengthy document that he completes. Then I consider my daily interaction with the patient during our daily therapy sessions. Then I talk to the attending psychiatrist. I talk to the nurses. Then I review the complete medical chart. And he agreed he did all that in this case. And then I think probably the most important thing, plaintiff's counsel got Mr. Kohlbacher to agree that Lakeside's own patient transportation policy applied to this case and that he complied with that policy. And pursuant to the policy, he had to take into account the patient's medical and psychiatric diagnoses.
What medical or psychiatric diagnoses do you need to tell the transportation people that the man's blind?
Judge Golden, there is no proof in the record that this man was blind. The proof is that he was legally blind, but during his 1-month admission at Lakeside, he was able to ambulate independently with no assistance throughout the hospital. He did not use a cane, a walker, or a wheelchair, and he did not suffer any falls. And so...
Did their records reflect that he was legally blind?
No, sir, it did not.
They did not?
No, sir. That came after the fact. The Lakeside records reference glaucoma as far as a vision problem, but there's no reference, to my recollection, that he was legally blind. But again, Mr.
Was he
Kolbach,
wearing a special tag on his wrist, a bracelet that indicated his limitations?
and that relates to Judge Stafford's question earlier about what does fall precautions mean. There was no proof in the record introduced regarding what does it mean when a patient is on fall precautions beyond, well, he's on routine 15-minute checks. The staff checks on him every 15 minutes, but that's every patient at Lakeside. That's not unique to a patient who's on fall precautions. I think Mr. Kolbacher may have mentioned that they're given non-skid socks, but there was no definitive list of things that are done to spell out what does it mean when a patient's on fall precautions.
Was he asked that question in his deposition?
I believe he was, and he was not really able to articulate very much. But his testimony was, if Mr. Dickerson had suffered a fall during his 1-month admission at Lakeside, or if he had used an assistive device, such as a cane or a walker or a wheelchair, then I would have probably conveyed that information to the transportation company, because that's going to have a bearing on the type of medical transportation that he decides to arrange. And that gets back to, again, the common knowledge exception. I don't even know, I don't think the average layperson knows what the various types of medical transportation that are available to patients, what types of services are out there, and more importantly, what type of medical transportation is appropriate for a patient who has certain physical limitations, medical conditions, or psychiatric diagnoses, because at Lakeside, that's a part of it as well.
Was the problem with him being, having issues being transferred, was it the falls or was it the glaucoma?
I'm not sure I understand your
Well,
question, Judge Stafford, I'm sorry.
And I'm not sure I know exactly what I'm asking, but was it simply the glaucoma, the vision problems, that caused the concern about the falling?
No, Judge Stafford. In fact, Mr. Dickerson was placed on fall risk precautions at the outset of his admission based upon a nursing assessment that was done that lists several different categories of limitations. And if you get a certain score, you're placed on fall risk precautions. And Mr. Dickerson received that score, and so he was placed on those fall risk
So the
precautions.
glaucoma was just part of the factors that he was assessed?
Well, actually, it was not.
Okay.
It was not. Mr. Kolbacher, I have to admit that in Mr. Kolbacher's deposition, he agreed that glaucoma, was a separate factor that resulted in, Mr. Dickerson being placed on fall risk precautions. But that's not really accurate if you look at the medical record. But, for the reasons I've just discussed, we would submit that, Judge Wagner's ruling finding the common knowledge exception to be inapplicable on the facts of this case, that be affirmed, and that her order granting Lakeside's motion for summary judgment in its entirety be affirmed.
All right, thank you, Mr. Cleek. Ms. Coombs, your rebuttal.
I would like to address several things, so hopefully I can get through. First, on the interdisciplinary master treatment plan, which is Exhibit 7 to Mr. Kolbacher's.
I'm sorry, I can't hear you.
Exhibit 7 to Mr. Kolbacher's deposition is the interdisciplinary master treatment plan. This is the document that has the independent basis for fall risk procedures. It has listed for Mr. Dickerson's medical problems, number 1, fall risk, poor vision. And then it goes on and talks about pain and nutrition. And then when it lists chronic, stable medical problems, number 1 is glaucoma, stable with meds, and number 2 is poor vision, safety, fall risk. So these are independent fall risk procedures that were placed because
And
of...
what is the document you're referring to?
It is I believe it was actually prepared by Mr. Kolbacher. It's called an interdisciplinary master treatment plan. So this is from, I believe, the date of admission. Most of these are the day after. they're completed, and then as additional treatment may change throughout the treatment, it can be changed, but it was never changed.
That was prepared by Mr. Kohlbacher?
It was. I want to address statutory construction. The Young case, looking at this section of the statute, said we can't ignore the words in a healthcare profession because of the statute, the tenets of statutory construction. Statutes must be interpreted so that every word and phrase has meaning and no part can become superfluous. Lakeside urges you to hold that in every HCLA case, the plaintiff must have a licensed MD in Tennessee or contiguous state. If that is what, to take that interpretation and agree with it would make superfluous and give no meaning whatsoever to the phrase, in a healthcare profession requiring licensure under the laws of the state. Had the Tennessee legislature meant to require a licensed MD in every HCLA case, then the statute would instead read, no person shall be competent to testify unless they're licensed in Tennessee or a contiguous state. It's not what the statute says. I would also like to briefly touch on the fact that, in fact, Mr. Kohlbacher was not licensed. This is not an area that requires licensure in Tennessee. If we look at all of his duties, he was not licensed. He was not required to be licensed, which again, he is not in a profession that requires licensure in Tennessee. Therefore, under the specific language of the statute, the plaintiff's expert is going to be testifying about a profession that does not require licensure in Tennessee. Very briefly on the common knowledge, opposing counsel mentioned that there was case law about that passing information along from one provider to another requires expert testimony. I'm not aware of that case law. I did not see it in their brief. If it's out there, I apologize, but I'm not aware of that and do not believe that that is the law, at least that has been presented in this appeal. Again, thank you so much. My time is up. Oh, no, I think my time is up. Thank you.
Thank you, Ms. Coombs and Mr. Cleek, for your arguments. We'll take your case under advisement. All right, we've heard 2 of the 4 cases on the docket. We will take a very short break.